We'll go ahead and call this meeting to order at this time. I want to ask Chairman Lumsden if he would open us up in a word of prayer, please.
With me. Dear Heavenly Father, we thank you for this day. We thank you for your love and your goodness to us, for watching over us and caring for us. And Lord, we thank you for the opportunity that you've given to us to be here today, to be in this role. And we just pray, Lord, for your wisdom and your guidance as we consider those things that come before us, and ask that you would guide us and direct us. For we pray this in Jesus' name and for his sake. Amen.
Amen. Thank you, everyone, for being here with us today. At this time, we're going to call on Representative Gullett from the 19th House District to present to us HB 347. You can sit at the table if you'd like to, be fine.
Thank you, Chairman. Thank you, members of the committee. House Bill 347 is one that passed out of this committee last year. And it got hung up in rules kind of late in the game, and didn't have time to address it. So here we are back again to talk about it. It's a pretty simple change that's made. It's on line 17. It's an or to an and. And I think the gist of that is, in my mind, is there are three classifications of sex offenders by the Sorb. So Sorb analyzes these people who have been convicted, analyzes them, the likelihood that they're going to have another sex crime, and they get tiered, they get level risked or risk leveled or whatever you call it. But what happens is there are three tiers. Tier one or level one risk today basically says if you met your entire sentence, then in the 10 years of lapse, whether you're level 2 or level 3 or level 1, you can petition the court to be removed from the list. Or if you're level 1, you can immediately petition the court to be released as a sex offender. What we're having happen is there are a number of people that are being let out that through a plea or whatever, they get reassigned. The risk or the actual conviction has been completed early. And so people are petitioning early at that point to get off the list. And there are judges in Georgia who are allowing that to happen. At the same time, we're one of the most lenient around the country. And we have people who are moving here because they know that our lax, how easy it is to get off the registry. So maybe their state's really difficult. They'll move here and move to a judge who seems to be doing this. And the reality is that these people who will never get off the list in their home state move here for 6 months, petition the court, and they get removed from the list. And that includes the other state. Some of the states that are more, I'm saying are a lot stricter than we are. California, more strict than us. South Carolina, more strict than us. Florida, more strict than us. There's a whole bunch of states. Alabama has a pretty complex one, but more strict than us. We are one of we're not doing it well here. And this is something that I think is important to all of our communities, and especially a number of judges here that have the ability to do that. So that's what we're trying to do, is change it to from an or to an and. So basically, you have to either have satisfied it, your 10 years, and be a level 1. Otherwise, you're on it for the remainder of your life. Sex offender. So this is felony. Also, I want to make clear, this is felony sex offender cases. This is not misdemeanor. This is not a high schooler dating a high schooler getting convicted. This is serious cases here. So, and again, you guys passed it last year. Happy to answer any questions.
Yes, we want to ask the members of the committee if you have any questions for the author of the bill. Before we open up to some testimony, we have some that would like to speak and give testimony about this piece of legislation. Any members of the committee wish to ask any questions at this time from the author? Okay. We have a couple of folks signed up, 3 folks signed up for the opposition. Maisie, if you'd like to come up, right there at the podium will be fine. Yes, ma'am. Thank you.
Good afternoon, committee, chairman. My name is Maisie Lynn Girton. I'm general counsel for the Georgia Association of Criminal Defense Lawyers. I'm joined today on Zoom by one of our members who's a practitioner in this area. His name is Bernard Brody. So certainly if you have particular practical questions, he's going to have frontline knowledge of that as he works on these cases on a routine basis. As a threshold matter, I understand the representatives' concerns about people moving into our state and leveraging our situation here. But if this is what we need for Georgia and Georgia citizens, and we aren't seeing a situation where people are at the judge's discretion being removed from the registry and then committing additional crimes, I'm not sure what the real fix is for Georgia and Georgians. And I would also remind you that the judges that are making these removal determinations are the same judges who made the sentencing determinations. They are intimately aware of the facts of the case. They know the person that is in front of them. They have been in the litigation from the start. And by the time someone gets to the point where they can actually petition to be removed from the registry, they will have completed their entire sentence. It's not necessarily immediate, depending on your definition of immediate. They will have had to complete their prison sentence if they had one, any parole that might have followed that, any other supervised release like probation. And then there are some additional criteria in a separate code section that's not included in the bill because it's not being modified, of course, by the bill. But in OCGA 1710 6.2, they have to qualify under subsection C1A through C1F. And those provisions include everything from having had no prior sex convictions. They cannot have used a deadly weapon, for instance, in the commission of the underlying crime in this case. There cannot be evidence of a relevant similar transaction, and it goes on. There are several others. So you can see that from the start, there is a narrowing in our law as to who can actually come and petition the court for removal already. And even then, when someone comes to make that petition, as Representative Gullett mentioned, it's the judge's discretion. The judges do not have to let someone be removed from the registry. And like I said, they are very intimately involved in the case and know the people before them. Moreover, it's worth noting that back in 2010, there was a pretty, I would call it an omnibus sex offender bill. It was House Bill 571. It was represented at the time, Speaker Ralston's bill. And at that time, we did have this 10-year provision in place, including the need to have completed your sentence. At that time is when we added this idea that a level 1 sex offender could petition prior to the 10 years. That's where this or comes in, that language gets added in 2010. So, I wasn't here in 2010. I don't know. I know that Representative Chairman Powell would have been here back then, but I don't know exactly why they did that, but I can imagine it's because level 1 offenders, by the time they are leveled, that is the lowest level that we have. That doesn't mean they get a low sentence. They could still have a 10 or 15-year sentence depending on the offense, because their leveling is based not only on the offense that they've been convicted of, but it's risk assessments and other evaluations that are done, as Representative Gullett mentioned, by Sorb. It's a very thorough process that they undertake to make those leveling determinations. The outcome of this legislation would mean only people who are level 1 would ever have a chance to be removed from our registry. This will eliminate the possibility that anyone that's a level 2 or a sexually dangerous predator ever has a chance. Not that they really have a high chance now, but at least they have a chance now. The other thing that's worth mentioning is that when someone is classified by Sorb, it's an administrative process, of course, and there's an opportunity for that person to ask for reconsideration. The rule is, though, you have to ask for that reconsideration within 30 days of the leveling. As you might imagine, for sex offenses, people are usually under sentence. They may be in prison at that time. They may be on probation, but that's, I'd have anecdotally rare. But within 30 days, the chances that someone has had the wherewithal to file for reconsideration is pretty low. And by the way, you don't have a right to counsel at this stage of the process. So if you were represented by counsel, let's say you had a right to an appointed lawyer because you're indigent for the underlying sex offense, for reconsideration with respect to the registry, you have no right to counsel. So if you don't make it within that first 30-day window to ask for them to reconsider you, you'll never have a chance. So when you get out of prison 15 years later, let's say, you finished your sentence and you now qualify to petition to be removed from the registry, you don't get a chance to go back now and say, I was a level 2 back then, and And that's fine. Back then I deserved that leveling. But look at the changes that I've made in my life in the last 15, 20 years. Couldn't you now take a look and see if I'm a level 1? Because only the level 1s, if this bill is to pass, are going to ever have a chance of coming off the registry. And what we know about sexual offense recidivism is that over time, the recidivism rate drops rather precipitously. So if you look, there's a 15-year sexual recidivism analysis wherein 14% of the offenders recidivate after 5 years of follow-up, but only 7% after 15 years. And realizing again that by the time we get to this process, for many of these people, we have passed a 10-year mark. We're moving into the 15. I realize there may be some light sentences out there. There may be some situations where someone doesn't get a harsh penalty up front, but that is going to be rare with the types of charges and offenses we're talking about here. Ultimately, what Gactel would say is that you can trust our judges, because even after meeting all the criteria that I've mentioned to you, the criteria that are laid out in Title 17, a judge can still refuse to remove someone from the registry. We understand that removal from the registry is a significant request. We're going to urge you to consider that the person that's in the best position to make that decision is the judge who heard the case and the judge who would be considering the removal. I would love to offer Mr. Brody an opportunity to say anything that maybe he thinks I've left a gap about. And if you all have any questions, we would both stand for those for you.
Certainly. Mr. Brody, are you with us online?
I am. Yes. Good afternoon.
Thank you. Do you care to add any remarks or comments at this time?
Well, I echo all the same concerns. I do, from a practical standpoint, I could address a couple of the experiences that I've had with some of these cases. So I am aware of defendants who are removed from the registry following the completion of their sentence, and what many prosecutors might view as a relatively short amount of time. But I will say a lot of these cases are what I consider to be kind of the borderline cases. These are the cases where these people were granted probation from the beginning. A lot of them were granted 5 years, sentenced to 5 years probation, 10 years probation. Some of these are like college kids, 19, 20-year-olds. So there are cases where people are sentenced for a sex offense or on the registry for a short amount of time. But these are people who are already perceived by the court to be very low risk because they were not incarcerated, sentenced to prison, obviously classified as level 1, and meet all the other criteria. And so, we put the discretion in the sentencing court. This is the same judge that issued the sentence. Prosecutors don't agree to these petitions routinely, so usually they are opposing them, and they have their opportunity to be heard and present any evidence that would be obviously to to deny the petition. But if the sentencing courts are granting them, there must be cause. And to just say that now we want to make this across the board rule that they all need to wait an additional 10 years, I'm not really sure what that additional 10 years is doing. I don't know if that additional 10 years is providing any additional safety to the community. I mean, if the same person is going to get off the registry, why would they need to wait 10 additional years? I just don't know what legitimate purpose that's serving. And also on the issue of the new rule, if this statute was amended, it would eliminate the ability for anybody who's a level 2 to get off the registry ever. I mean, just think of a situation where somebody's 22 years old and gets sentenced and gets classified as level 2, serves 15 years on, probation or parole, and now is in his, almost 40 years old. He's a completely different person, has no mechanism to petition for removal from the registry. It'll be because there's no mechanism to ever revisit the classification that he gets from Sorb. And so that, I think, is an inherent problem. Unless there's some sort of mechanism in place to readdress classification down the road, decades later, for an individual, then to permanently disqualify that individual from the ability to seek removal from the registry, I just don't think is right. I just don't see how we can make a judgment at one time that can affect somebody for many decades. And so I just think, like what Maisie Lynn had said, people do change, and we believe in rehabilitation. And so the idea that nobody who's ever a level 2 will ever have the ability to seek removal, I think it's pretty arbitrary. I think there's also, there may be a very small distinction sometimes between somebody who's a level 2 and somebody who's a level 1. And so I think that needs to be addressed if we are going to amend the statute.
I have a question from member committee number 23. Who was that down there?
Thank you, Mr. Chairman. Thank you. Just a quick question. So confirming, this bill is adding 10 years without judicial discretion. Is that correct? I'm trying to make sure I'm interpreting it correctly.
No.
So it's not, well, it's not adding 10 years. Right now, the way that there's sort of this two mechanisms by which you could request removal. One is if you have, you'll see this at lines 15 through 17 of the bill. 10 years have elapsed since you completed your sentence, whether that's prison, parole, supervised release, or probation.
Right.
So you've completed that, plus you've added 10 years, then you have a right to petition. And that's irrespective of which level you are. You could be a level 1, you could be a level 2, or you could be a sexually dangerous predator. And after that additional 10 years beyond your sentence, you could petition. Or today, if you're a level 1, you don't have to wait the 10 years, but you do, because of Title 17, have to have completed your sentence. So to the extent that it's immediate, it's because the person has completed all of their carceral punishment or probation punishment or whatever their punishment is. Their sentence is complete and they're a level 1, and now they can petition. So what the bill is doing is saying, if this were to become law, the only people that will be able to petition are not only going to have to be level 1 people who've completed their sentence, but then also waited 10 years. So it does add 10 years to a level 1 tiered person's ability to petition, but it doesn't add it to anyone else's. They already have the 10. Well, they won't qualify anymore, so it's not adding it to anyone else.
Gotcha. Thank you.
Sure.
Representative Evans.
Thank you, Mr. Chairman. So this issue that Mr. Brody brought up, would the representative be open to some type of solution where there is a possibility of the defendant to appeal his level later, sometime later? I don't know when we would do that, but that's something I'm interested in learning about.
It's committee process. So if that's something the committee wants to do, we'll work through it. Is that what I'm looking to do at the moment now? Sorb last year, I haven't taught him this year. Last year, Sorb, who tiers these people out, who analyzes them, was in support of the bill. I don't know if they still are or not. I don't know if there's anyone here. Hopefully they can speak to it, but the way I wrote it. So if the committee wants to do that, then we'll go down that path. If they don't, then I'm good with my bill today.
Could I respond as well?
Go ahead.
So I can't speak for Sorb, and I do not see Ms. Albert or any of the other people from that agency here. But what I can say from a defense perspective is that if there is not some sort of re-leveling opportunity contemporaneous with this new removal petition, what this will potentially drive is a lot more reclassification petitions happening in those first 30 days. Because it will be that we will have to start advising our clients, you need to immediately file for reconsideration, because if you don't file now, you'll never have another chance, which is also kind of futile, right? We all know that within 30 days of a leveling, your circumstances are probably not going to have changed sufficiently enough that your level is going to change, but it's your only fighting chance. And if you never take it, you're never going to get it. And so, I mean, I guess from a, efficiency standpoint, it doesn't seem very efficient. Not that, but that's the way the system is set up. You only have those 30 days to ask for that reconsideration. Unless there were to be some modification allowing for a reconsideration contemporaneous with this scheme that's laid out in this bill.
Chairman Powell.
Thank you, Mr. Chairman. I'd like to ask a question. Maybe you could help clarify something in my mind, because it's been years since we've dealt with this code statute. There was a period in time that we used to have some questions about the prosecution of some cases, that there were some other charges that would be considered to put somebody on the sexual registry that didn't have anything to do with the sex offense in a lot of our minds. Could you address that? I mean, some of these, if I remember right, if they were charged with kidnapping, kidnapping is kind of interesting. If you get somebody in the back of the car and you don't let them out and you take them off somewhere and you're not doing anything to them. But at one point, if I remember right, there were people that were going on that was being treated as a sex offender statute. Could you address that?
I'm gonna phone my friend Bernard Brody, because I believe he can address it more completely than I can. But I agree with you, that has been the case in history. I don't know if it is now.
Bernard, you still with us there?
Yeah, I'm here. And that was an issue that I believe has been addressed. And there's actually, I think, a mechanism for somebody who was put on the registry for an offense like kidnapping that has since been, declared an offense that does not require registration to be removed. So there have been some safeguards put in place over the last, 10 years or so to address that concern. If that answers your question.
I think what you said is that has been addressed, that some of those
Yes.
zealousness of the prosecution on some of these charges is no longer been treated as such.
Well, what has been done is there's been an amendment to the registration statute that has removed like some of the kidnapping charges that didn't aggravated assault, kidnapping, things that did not involve sexual acts, to remove those offenses from future sentences from requiring registration. So there may have been people who, prior to that amendment of the statute, were on the registry, but the registration removal statute actually allows those people to petition for removal. So I think that those two amendments to the statutes addressed that problem.
Thank you.
Chairman Powell, PAC has assisted me with a code section review, and kidnapping of a minor child under the age of 14, Robert, remains a registry offense without sexual contact. But and so does aggravated assault with attempt to rape without an actual completed rape. Both of those remain registrable offenses.
Okay. Interesting. Representative Holcomb.
Thank you, Mr. Chairman. I want to just make sure that I understand the overall concept, which is this issue is a very charged issue. It's a very emotional issue. And what we're dealing with is long after conviction, long after sentencing, but after all of the punishment has been completed, after somebody's satisfied everything that the criminal legal system has asked them to do in terms of punishment, parole, post conviction activities, this is just the issue of keeping them on the registration or not, correct?
Right.
Okay. And I'm looking at the statute, and it's kind of interesting, and I would commend it to the other members of the committee because I think it gives good context, because some of the individuals who are presumptively or should presumptively be removed are those that are confined to a hospice facility, skilled nursing home, residential care facility, totally and permanently disabled, otherwise seriously physically incapacitated due to illness or injury, with the idea behind that all those categories of individuals are very unlikely to commit additional crimes. I also agree with the statement that you made referencing the study, is that the time frame for recidivism, it's much greater earlier. In other words, as individuals get older. So I understand the purpose of the bill, but I do have concerns about it being punitive isn't the right word, but just a little strict for a category of people who, granted, are not sympathetic. And I'm not going to argue that they are, but at the same token, to have some system by which they can no longer have to register. And so with all that, I guess the question that I'd like to ask, because I don't really know this area very well, is can you just describe for us, and I apologize if I missed it, how the safeguards work of making that evaluation of how people are assessed, and just that process, and what is the current mechanism by which we feel comfortable as a state of releasing people from this obligation to register?
Well, the leveling decision on the front end is handled exclusively by Sorb, executive agency. It involves, so for instance, things like the offender's age is a factor in their level, right? Because if they're a younger person, their level is going to skew higher potentially than an older person, other facts being the same. There are evaluators on staff at Sorb. They also interact with the GBI, and each month the board, the members of the Sexual Offender Registry Review Board gather to review what the evaluators have said and done on the cases. And it's only at that point that the level holds. And we monitor their convenings, and it is not unusual for one of the members to raise a question about someone, to say, this person's been leveled as a 1. I don't know, what I see in the case file makes me think they should be a 2. Let's talk to the evaluator and find out why. And on occasion, the evaluator's explanation is sufficient and the person remains a 1. And on occasion, the evaluator's explanation causes them to reconsider, and then they get put back in for another evaluation. So it's got several, I guess, checks along the way, and then ultimately the board is the final arbiter. With respect to when you come off the registry, it's a judicial decision, and it's an adversarial judicial decision. I know that today, Mr. Brody and I have characterized some sentences as long that I'm sure my brethren across the aisle is grinning about, because he doesn't conceive of a 5-year sentence as being long, or a 3-year sentence, or whatever it is. We'll have a difference of opinion, I'm certain, on what constitutes a long sentence. That said, no one comes to this process, no one gets before a judge until whatever sentence that judge deems sufficient punishment is completed. So there is the rubric that's outlined in 1710 6.2, which is another set of qualifiers to get to this removal process. And then you step into this 42.119, wherein today, if you are a level 2 or sexually dangerous predator, which we sometimes call 3, you have to wait another 10 years before you can be considered for removal. And or if you are a level 1, so if you're a level 1 person, like Mr. Brody mentioned, who for whatever reason got a 5-year probation sentence on one of these registerable offenses, because I'd also say too, and I appreciate your question, Chairman Powell, because not every sexual offense, even the sexual offenses, are not always what we call touch offenses, right? Some of them are just, I don't mean to say just like it's not violative of people, it is, but they're image cases, right? Where there's no actual touching by the person that's going on the registry. The harm that they've committed against our community is not one of physical harm, but not to discount the harm that it does bring. But all of those factors go into the sentencing judge's decision about what the right punishment is. And once that punishment is complete, that level 1 offender does have quick access to removal from the registry. And I guess I would say that the best descriptions I've been able to locate about these levels are probably worth mentioning. So one is the lowest level, and the lowest level is an individual who is considered a low sex offense risk and a low risk for recidivism. And again, it's not predicated on the offense by itself. There's a whole suite of factors, age, disposition, other things that come out in their psychosexual evaluations. Level 2 is a sexual offender that's an intermediate risk of committing sexual offenses, and an intermediate risk for future recidivism. Essentially, a level 2 person is someone who doesn't quite qualify for a level 1, but they also don't reach the high level of what we call a sexually dangerous predator, which is someone who is a high risk of perpetrating future dangerous sexual offenses. So the idea that someone through the course of their life, at the time that they've served, during the time when they're serving their sentence, and in the level 2 and sexually dangerous predator cases, those additional 10 years, the chance that they have come to a place where their recidivism potential has diminished is high. And the statistics tell us that over time, your chance of recidivizing drop. So the idea, back to what Representative Evans was raising, the idea that there wouldn't be some opportunity if this scheme were to be adopted to reconsider their classification. I mean, I don't know for sure, but I'm sure some of my colleagues would want to raise a due process constitutional claim against that kind of a statute, to say that you are being, the notice you got for the level that you are is whatever, 10,
You
15,
can talk
20
about
years
that in
old.
judiciary.
Yeah, I know. The crossover between public safety and
Floor
criminal
Leader
procedure.
Lott, you have a question, comment?
I do, yes, please.
Go ahead.
Thank you, Mr. Chairman. So my question is this then, is it accurate, or did I understand you correctly, that you only have 30 days to ask for reconsideration on your level?
On your reclassification, right?
And so my second question would be then, is that not the bigger concern? That, see, you've given them a level 2 intermediate risk of recidivism and repeat offense, intermediate level.
Right.
So is the concern not that they should be reevaluated by Sorb? And how do we get there? And I don't necessarily believe that that has to do with his legislation specifically. That's
Agreed.
just a bigger question that needs to
Agreed.
happen. But this legislation that he has brought forward is addressing the fact that, and to some degree, he's asking that if you've deemed somebody currently an intermediate risk, that we want them to wait an additional 10 years. And if your concern is that they may no longer be an intermediate risk, then that is the responsibility of Sorb or us or whomever to figure that out. That's separate from this legislation.
Except that under this legislation, that level 2 person, for instance, won't have a chance at removal unless you address the fact that they can't reclassify. You by this legislation, without changes anywhere else, will prohibit anyone apart from a level 1 offender from ever being removed from the registry.
And so just one further question then. So has that been brought up? Has there been has anything been brought forward to address that concern? Because I have to agree to some level that his legislation is stating that an intermediate risk person is going to be required to do something. But you and I are in agreement that the problem is that they may actually no longer be an intermediate risk. Has anyone brought forward that possibility of whatever it takes, whatever it deems necessary to get Sorb to do, or to at least offer a reevaluation beyond the 30 days?
Not that I'm aware of particularly, but I do know, like with so many situations in our in the executive agencies that are within the criminal legal system, things are incredibly backlogged. It wasn't that long ago that the AJC reported on Sorb's current backlog. So as much as I would love to have that conversation, I'm not sure how realistic it is to ask them to add additional evaluations at this point in time, but certainly we'd be open to coming to that table anytime, because not only are the folks at this stage of their prosecution without counsel unless they can afford it. The timelines are just not set up to be helpful.
Maisie, can I add something to that?
Please go ahead.
As of right now, the only difference between a level 1 offender and a level 2 is the amount of time that they have to wait after the completion of their sentence to petition for removal. As we are right now, a level 1 offender can petition for removal after the completion of the sentence. A level 2 offender must wait the additional 10 years before requesting removal. The proposed amendment to the statute will eliminate the ability for anyone who's a level 2 from ever petitioning for removal. So as we stand right now, there's not really any permanent difference between a level 1 and level 2 offender other than this additional 10-year delay. But if the statute is amended as being proposed, it will create a permanent distinction between a level 1 and a level 2 offender, whereas a level 1 offender will still retain certain rights and a level 2 offender will have none of these rights forever. So that's, I think, the big change that this proposed amendment would cause.
At this time, we want to hear from Matthew Rollins on 347. Maybe give us a little different perspective there.
I might. Mr. Chairman, committee members, thank you for hearing from me today in regards to this bill. My name is Matthew Rollins. I am a prosecutor with the Paulding Judicial Circuit. I've served as the acting district attorney for the last year, but I've been a prosecutor for a little over 10 years now. And I stand in support of this bill for a number of different reasons, but listening to Mr. Brody and others on opposed to the bill, I want to clarify a few different things that I think everybody's sort of asking questions about. The current state of the law, I think, has been settled. It's 10 years or level 1. Well, what that has created, and I don't believe it was the intent of the authors of this original legislation or this code section, was early termination. What we see now happening, and it's not just in Paulding County, but we now see defense attorneys bringing their clients or defendants coming before the court and asking the court to early terminate their probation and remove them from the sex offender registry. So they might have a 10-year probated sentence or 10 served 5, and now they have that last 5 years. And what is taking place is a judge will grant their early termination of probation and remove from the registry before their sentence was ever completed. And a point was made that the judge that is making that determination is the same one that sentenced the defendant. That's not actually usually the case, at least not in my experience. Maybe that's being experienced other places, but it doesn't work because of the time. If you have a defendant who is tried and convicted of child molestation, sentenced to 10 years or sentenced to 20 years, or something along those lines, and they come back before the court to petition, they're coming back to the court 10 years later. The chances of that judge still being on the bench at that point in time have gone down. These judges are moving on, they're retiring, and a substituted judge is coming in that has to hear that petition and make a new evaluation based upon that. The next thing I like to turn to is what does it mean to be on the registry? Because I want to make sure we're all clear. It's not just their name is on a list and their address is there. That's a very important part of the registry because it tells parents, it tells communities where they're at, but it also says their contact with children, their unsupervised contact, where they can live, where they can work, because we're preventing contact between this sexual offender and children. It's to protect those children, and that's what's in place. So there's a number of different things that are happening there. When a defendant petitions to be removed from the registry, he has to apply to be leveled by Sorb. So that's when that leveling is taking place. And I speak to Sorb agents fairly regularly, or the Sorb investigators, and a recent conversation with them just last month is they get laughed at. And the reason they're getting laughed at is they're getting laughed at by other states. They have to contact the state where this defendant was convicted and get their conviction information. So they've moved now to Georgia. They're petitioning to come off the registry. So we got to call back to that state and find out about it. Well, they contact their counterparts in that state, and the counterpart is like, hold on, what? They couldn't come off the registry here. That would never happen in my state. And so they get laughed at on a regular basis. And I can tell you, I don't know what their Sorb's current position is, but the agents that I speak to, they're wholeheartedly about making it more tougher to get off of that, off of the registry. Another point that was made that I would like to address just briefly is that the defendant was complete. That is not the case anymore. But what happens by this, by not having that 10 years from the completion of the sentence, by not requiring that, is you have a defendant that's on probation and on the sex offender registry. So they have themselves a felony probation officer supervising them. Plus they have the sex offender registry component of everything that they're doing. Well, if you turn around and you remove them from probation and then turn around and immediately remove them from the registry, you've gone from all of that supervision and all of that control over their behavior to no control whatsoever. We're now going to back off and you're going to do what you're going to do. And what we see, and I understand it was earlier, it was stated earlier that we're not seeing additional crimes. I don't know about another jurisdiction. I can tell you that we are. Last year I came down and I testified at the subcommittee, and I testified before this committee in regards to this bill. It then went to rules, and I understand I don't know how things sort of disappear in places, but it didn't come out of rules, and now we're back here. But since then, and I won't utilize the name because of pending litigation, so I don't think that'd be appropriate. But since then, just a case in point example, have a defendant after a jury trial was convicted on 10/21/2003 of child molestation. He was given a 10-year probated sentence. On 10/18/2016, he was released from the registry pursuant to petition. We opposed it. We fought it. He was released because he met all of the qualifications that have been stated before you. And he went from no more registry. Less than 2 months later, he started molesting his niece and recording those. And we have the recordings. It's over 1 terabyte of recordings over a 5-year period. It's because he went from a state where he wasn't allowed to have contact with any juveniles to now, let's let him babysit my niece, because people didn't recognize because he was listed as a level 1. They did not have that time period because of the current statute. We need that time period, that 10 years. As far as level 2s and level 3s, I'm sorry, I don't believe they should ever be released from the registry. They pose a danger to our children. They pose a danger to our community, and they need to stay on the registry because we need to have supervision over them and watch what they are doing. With that, ladies and gentlemen, I do ask that you support Representative Gullett's bill, and I will answer any questions you might have.
Any questions at this time? Representative Holcomb.
Thank you, Mr. Chairman. I hear you, and I think what I'm wrestling with is the aspect of a lot of these crimes are particularly heinous, and the victims are greatly impacted. But at the same token, they go through trial, the jury listens to the evidence, the judge listens to the evidence. There's a sentence that's issued that is deemed to be appropriate and for the public safety. The individual then serves that sentence in addition to the parole and everything else. And at some point, that oversight from the state, in some cases, probably should stop in terms of that individual not posing a risk. And for example, I listed off some of the issues of if you're in hospice, if you're disabled, like all of those type of things. So conceptually, it's a challenging line to draw because none of us have a crystal ball of who are the people who won't commit another action. And just being registered, I don't think is in and of itself going to stop somebody from committing an action. I think there's other factors that contribute to criminal behavior, but this drawing the line aspect of where to do it, and as I see it, besides the level 2 and level 3, is do we add an extra 10 years or not? And we do have the safeguards of it has to be then heard by judges again. And as you said, I think the normal position of most prosecutors is likely to be opposing of those, correct?
Yes, sir.
So how often is it that the judge doesn't agree? And I know your experience is probably just limited to yours, but my sense is probably most of the time the judges probably side with the prosecutors over the defense lawyers, or do you have a different experience?
It varies from courtroom to courtroom and jurisdiction to jurisdiction, really, as far as how the judges handle those. I can tell you in mine, there's at least one judge that he's going to grant it every time. Now, and you stated the hospice, and I don't disagree with the hospice and those provisions within this, and I believe Representative Gullett disagrees with those. Those individuals, if you're in hospice, you're not posing a threat anymore, and I understand that. This is to address those that could and do still pose a threat. A level 1 offender going straight from probation and sex offender registry, a level 1 offender going straight from there right off, and we're going to no supervision whatsoever. That is a danger. That's a danger because we're now, when they're on probation, when they're on the registry, their phone is subject to search. Their person is subject to search, looking for those pornographic images that they shouldn't possess. All of these kind of factors that trigger a sex offender, trigger that sexual behavior, is watched. It's maintained. It's I won't say it's maintained. That's a bad term. It is watched and supervised by somebody. When you go from hey, you're level 1, so now that you're done with probation, we're going to be done with your registry as well. You're setting yourself up, and you're setting that defendant up for failure, 1, but you're also setting up the community to be at risk. So I don't believe that the risk it's a risk versus reward. I think the risk is still too high with somebody that hasn't had time on the registry without being on probation to just cut them off like that.
And Mr. Chairman, if I may, because I don't know, I'm not an expert in this area. Can you just explain to us what the public safety benefits are of an individual being on the registry?
Yes, sir.
You alluded to some of it now, but if you could give the full picture, that would be helpful.
Certainly. So where most of the public and I would expect most people here are familiar with the address requirement and reporting that, and we can Google where are they in this county or in that area code, where are they living. That is one aspect of it. Homeowners that are looking to buy a home, we're going to look there if they have small children. That is one aspect of it. But you also have their interaction is curtailed through other means. Where can they work? The individual I was speaking about before was a postal delivery man. So you can't do that because now you're going to be driving through neighborhoods with children and that type of stuff. So you're not going to expose the defendant to children. So it lessens the defendant's opportunity. But it also, so it's where you live, where do you work? But it's also what images can you have on your computer or your phone or digital media of that type. You're not allowed to possess those sexual images and that type of thing. You're not allowed to possess that because it could trigger those kind of things. So all of these, and there's more, and I don't have it right in front of me, but there's a number of them there. It's all addressed to prevent the defendant from recommitting a crime, and which obviously has the impact of protecting our children.
Okay. So if I may, Mr. Chairman, because this issue of children, I think, is interesting because not all sexual crimes are against children, right? I mean, there's adults that rape adults. So is your primary interest on protecting children, or is it broader than that?
I believe it should be. It's more than that. I would say the majority of cases that we're talking about here are aggravated child molestation, possession of child pornography, those types of cases. The rape case, if you've been convicted of rape, that's an extremely long prison sentence.
Exactly.
Where that one, there's, and depending on how old you were at the time, I mean, that's going to change on your danger to the community. A lot of those defendants aren't coming out of prison. So that's a lesser portion of the cases, but I think this does apply to them as well. Yes.
Okay.
All right, Ms. Evans, we got time for one brief comment from you. We need to move on from this.
I apologize for taking up too much time.
That's okay.
Thank you, Mr. Chairman. Is there any way that we could control if the sentence is terminated for early probation, that they still stay on the sex registry list? Is that?
I believe, I'm not being sarcastic in any
No.
way, ma'am. I apologize, but I
Mhm.
think this bill does do that. So if they early terminate
Okay, no,
that
that's-
probation, they still have that 10 years that they must be on the sex offender registry before petitioning to be removed.
Okay.
Okay. Any closing comments from the author of the bill before we?
I appreciate you guys hearing it. I'm sorry. It took a while. It is something we did pass out last year of committee. We are the lighter ones of the other states. If you look at other states, even at the federal level, tier 1, after 15 years, if you're tier 3, you never get off of it.
Okay.
So I appreciate y'all's consideration of this bill.
What would be the desire of this committee at this time? Motion is made and seconded. All those in favor? All those opposed? Okay. Bill carries.
Thank you, guys.
Sir. Next item on our agenda is going to be HB 1146. Representative Lott, if you want to present right there where you are, that'll be fine with the chair.
Thank you, Mr. Chairman. I am here to present LC 393190. And this is a Department of Public Safety agency request. This actually is a fairly simple bill. There were only 2 significant changes. One is on line 24, where it specifies that the lights are primarily blue in color. You'll see that again on line 24. And then the other, beginning on line 27, it has removed one sentence, and the sentence reads, or a portion of the sentence that reads that the Georgia State Patrol shall not be permitted to have more than 2 vehicles per post without such exterior mounted roof lights. So this legislation is brought forward so that the posts can have as many of their vehicles as they choose without the rooftop bar lights, meaning that they may now have more than 2 within a post that are slick tops. This bill is brought forward again by Department of Public Safety. It allows for uniformity. It allows for the newer designs. Newer technology has the lights within the vehicle, within the grills, front and back. This legislation changes nothing about the markings on the vehicles and it really doesn't decrease their lighting ability and capacity.
You know, I look for this as an equalizing bill. It levels the playing field with the amount of technology you have now that'll warn you online if there's a radar check somewhere. This seems to level the playing field in my mind as a state legislator, that you can't see these cars as much if you're at a distance, and so I think this is a great piece of legislation that allows Georgia State Patrol to do what they need to be doing, enforcing the law.
Sure it does.
Any questions from the committee at this time? What would be the desire of the committee? Okay. Is there a second? All those in favor say aye.
Aye.
All opposed? Okay, motion carries. No other business before this committee. We stand adjourned. Thank you.